Obviously, the big issue yesterday with jury selection was the allegation presented by the defense that Mark Leonard had hired a hitman to kill a witness, allegedly. I mean, from your perspective, do you see that as a defense strategy? Are they trying to desensitize the jurors to things they're going to hear later in the trial?
What was interesting was that prior to what occurred this week during jury selection, with that allegation being let out there, the defense had struggled mightily, but failed to actually keep that fact from the jury. Basically, having a motion in limine, which is a preliminary motion that the judge rules, saying that they can't talk, the prosecution can't talk about that fact. And the reason that's important is that the defense doesn't want to piggyback that fact onto the fact that the defendant may or may not have done what he's accused of doing. Does that make sense?
Sure.
So the important point here, I know you're going to edit this because it's long, but the important point here is that basically they fought, they struggled. The judge said, no, that is an important fact. It's something that happened after that does go to show that the person, may have committed the crime that they're accused of. That's going to come into evidence. So the defense says, okay, fine. If it's going to come into evidence, then we have to make sure that the jury knows about it and that they can separate out that fact from the point of whether or not they actually committed the arson.
Sure. And what we saw yesterday is that they're going to have a hard time severing that fact out, it seems like. I mean, do you see that? Obviously, they're going to hear about it again during the trial. If they had so much difficulty with it, even before they've seen anything else, the physical evidence, DNA, technical evidence, I mean, how big of an obstacle is that going to be for the defense?
It's interesting. It cuts both ways for the defense, because if the judge doesn't allow them to talk about that fact during jury selection, but then that hit for hire comes into evidence during the guilt phase, then that could potentially be an error that would be reversed at the appellate level and basically undo all of the work that the prosecution does. Because think about this. The defense says this is such a bad fact that it shouldn't come in. Prosecution says, yeah, it's a bad fact. The reason why we want it in is because it's a bad fact. And then that bad fact isn't actually talked about, and the jurors aren't given an opportunity to make a decision about whether or not they can separate those things out and make a decision just based on the evidence and the facts alone.
As far as the delay, I think the most recent update we got was that they're up to 9 jurors now. They were hoping to be done by the end of the day and start the trial on Monday. Looks like that's going to be pushed back. I mean, do you see that impacting the prosecution or the defense more, especially since the prosecution has obviously a series of witnesses set up for each day? I guess where do you feel they stand on that?
Yeah, so the prosecutors drive the train throughout this phase of the trial. I think the defense is only scheduled for maybe 1 day of evidence, and so any sort of delay, setbacks, always cause the prosecutors to have to jump through more hoops in terms of making sure that there are plenty of witnesses to fill up a day's testimony, witness schedules, all of those things. You can be subpoenaed for a certain time, but that doesn't mean that you're going to actually go and testify at that time. Plus, the difficulty is also compounded by the fact that it's in St. Joe, so several hours north of Indianapolis where the incident occurred. So there's all sorts of logistics and expenses that come into play anytime a trial is delayed.
Sure. You've had you prosecuted a major trial, had a big venue change, and you just mentioned the venue change here. Obviously, the defense requested it for the hope of getting an impartial jury, but for the families of the Richmond Hill victims, people who live in the neighborhood, and for the witnesses too, that's a big impact for them. It's 3 hours away. There's no accommodations for the families. It's, I imagine, hard for the prosecution too, and probably defense. They're Indianapolis based. What are the challenges of that? We asked you yesterday just about the length of the trial being challenging, but not only the length now, but also being, 3 hours away in St. Joseph County.
So for the lawyers, it means that, for every trial you have to be, 100% prepared, 120% prepared. You can't be over-prepared for trial. But when you move that trial 3 hours away, that means you have to be even more prepared. You have to have everything with you. They take a semi-load worth of evidence up there. I'm sure they've been up there for a couple of weeks anyway, preparing. But just, even simple things like, the logistics of the courthouse, and even the different, not only each jurisdiction, but each court has its own particular way it likes to do things. And so you've got the challenge of basically learning that immediately. You don't have the benefit of being in the same courtroom with the same judge for years and years. And so that's a challenge for both defense and prosecutors. And, for the family, the victims, those who have been affected, it would be really difficult for most people to stay up there for the amount of time, necessary to sit through the whole trial. That probably won't happen.
Sure. You said, obviously the prosecution is the one who drives the train, like you said, and they do. I mean, they last Sunday they caravanned all the evidence up to St. Joe, so it's certainly, as far as physical evidence goes, mountainous. There's a lot there. It's one of the reasons why the trial is going to take so long. When you have that much evidence, I mean, not just DNA evidence, not just technical evidence. I mean, they've photographs, insurance estimates, all kinds of stuff probably can't even imagine yet. And you're the prosecutor. You got to keep a panel of, 12 jury members. You got to keep the judge, from not going off the rails themselves as far as boredom, as far as paying attention to the point you're trying to make, which is that this, man or woman is guilty. How do you keep those things moving?
So, you just mentioned a lot of really important things. You've got to transport the evidence. You've got to catalog the evidence. You've got to organize the evidence. You've got to secure the evidence, right? Because if there's any evidence that the evidence has been tampered with, that creates a whole other host of issues and problems for the prosecution. And then, after you've done all of that, then you have the challenge of presenting the evidence in a way, like you just said. It's not television. It's not CSI. Crimes aren't solved in 48 minutes. Oftentimes it takes weeks, and this trial is scheduled, I think, for 6 weeks or something. It's a really long time to keep people's attention, and so that's a huge challenge. The trial is not supposed to be entertaining. There are legal boxes that have to be checked in order to prove someone guilty of a crime as heinous as this. But you don't want it to be boring, and so that's a challenge for them.
Sure. As far as those boxes go, arson is, I think you said yesterday as well with Raphael, kind of a uniquely difficult, or it has its own unique set of challenges to prove that someone committed arson. Did you ever prosecute an arson like this? And maybe you can walk us through sort of what's different. It's a murder case, but it's also a murder case allegedly caused by an arson. So
it's very arsons are very difficult to prove because most times you don't have eyewitnesses, and much of the evidence in an arson case is it's physical evidence, and it becomes a little bit more of a who done it and how you done it than what I would call sort of a typical murder case that you see being prosecuted throughout the United States. So it is a very difficult case to prove, and without commenting specifically on the evidence in this case, I do think that the state has a strong case, but again, they can't take anything for granted. And this defense team, look, what they did with the jury selection and fronting that bad fact out was I think a really good move, because it put both the prosecutor who'd been asking for that for the entire time, and the judge kind of in a box. And so this defense team is not one to be trifled with, and so it'll be an interesting matchup.
Last question, I guess. A lot of attention's been paid to that hitman allegation, and that's going to come back up, and that's going to be a bigger issue later in the trial. Is there anything you see topping that? Maybe Monserrate Shirley's testimony is probably certainly going to be up there. If you were prosecuting the case? Would there be some particular sort of physical evidence that you look to that is, basically the smoking gun?
What's interesting in any trial that's being prosecuted is that oftentimes one side will think that, oh my gosh, this piece of evidence, fact A, is going to be the aha moment, for the jury, the smoking gun, so to speak. But sometimes the way trials play out, it could be something completely different. And what's really interesting is talking to jurors after big trials about the facts that they did key in on, the facts that they did think were important. And sometimes those facts are not what you think. So I think we just need to stay tuned and see how this plays out. And as important as all of that will be the judge's rulings and how he handles some of this adverse evidence to the defense.
Okay, thank you very much.
And remember, so here's the last point.
Yeah.
Is that the state's burden of proof is enormously high, and they don't often talk about this, in the media, television shows, and that sort of thing. They have to prove beyond a reasonable doubt that the way they said it happened, the way they said the crime occurred, is the way that it happened, and that there is no other reasonable way that it could have happened. And so watch for the defense throughout this trial to be keying in on that point and trying to put doubt in jurors' minds as to how the prosecution is trying to convince them that the crime occurred.